In this series of lectures on Information Technology Act of 2000, already we have discussed two questions. So, the first question that relates to digital signature and electronic governance, and the second question that we have discussed relating to attribution, acknowledgement, and dispatch of electronic records. And in this lecture, we would like to discuss question number 3, and that is give a critical assessment on the regulation of certifying authorities. So, the very answer to this question falls under section 17 and 18 of the Information Technology Act, and that is relating to appointment and functions of controller. So, the very appointment of the controller and the deputy and assistant controllers are made through official gazette by the central government, and also the qualifications and the requisite experiences are also determined by the central government as per the provisions of section 17 of the Information and Technology Act, and as while section 18 of the act provides the very functions of the controller. So among those functions of the controller is exercising supervision over the activities of the certifying authorities, or also certifying public keys of certifying authorities, laying down the standards to be maintained by the certifying authorities, specifying the qualifications and experiences which employees of the certifying authorities should possess, also specifying the conditions subject to which the certifying authorities shall conduct their business, also specifying the contents of written, printed, or visual materials and advertisements that may be distributed or used in respect of a digital signature certificate and the public key, also specifying the form and content of a digital signature certificate and the key, also specifying the form and manner in which accounts shall be maintained by the certifying authorities, also specifying the terms and conditions subject to which auditors may be appointed and the remuneration to be paid to them, and also facilitating the establishment of any electronic system by a certifying authority, either solely or jointly with other certifying authorities, and regulation of such system, also specifying the manner in which the certifying authorities shall conduct their dealings with the subscribers, also regarding resolving any conflict of interest between the certifying authorities and the subscribers. Also, the controller has the power laying down the duties of certifying authorities, and also maintaining a database containing the disclosure of record of every certifying authority containing such particulars as may be specified by regulations which shall be accessible to public. And now we will discuss the provisions relating to licensing to digital signature. And under the provision of license relating to digital signature, First, we'll deal with application. So, regarding application, Section 22 of the Act provides that every application for issue a license shall be in such form as be prescribed by this central government, with the very particular statement which include the procedure with respect to identification of the applicant, payment of such fees, and also such other documents as may be prescribed by the central government. And regarding issue of license, would like to deal the provision of Section 21 of the IT Act of 2000. Any person may make an application to the controller for a license to issue digital signature certificate, and the controller is the only authority to issue digital certificates as may be prescribed by the central government. And now we would like to discuss the very renewal of that license. So, an application for renewal of a license shall be made in such form and accompanied by such fees, and it would be met to by the central government and be made not less than 45 days before the date of expiry of the validity of the license. And now we would like to discuss the provisions relating to grant of license. So, the very grant of license and the procedure and rejection of the license is provided under Section 24. So the controller may, on receipt of an application under Section 21, after considering the documents accompanying the application and such other factors as he deems fit, grant the license or reject the application. And now we would like to discuss the provisions relating to suspension of license as provided under Section 25 of the IT Act. The controller may revoke the license if he is satisfied after making such inquiry as he may think fit that a certifying authority has made a statement in or in relation to the application for the issue of renewal of the license which is incorrect or false in material particular, failed to comply with the terms and conditions subject to which the license was granted, or failed to maintain the standards as specified under Section 20, or has contravened any provisions of this Act, rule, or regulation, or order made thereunder. However, no license shall be revoked unless the certifying authority has been given a reasonable opportunity of showing cause against the proposed revocation. And now we would like to discuss the provisions relating to Section 26, which provides regarding notice of suspension of revocation of license. So, where the license of the certifying authority is suspended or revoked, the controller such matters must publish notice of suspension or revocation as the case may be in the database maintained by him, and where one or more repositories are specified, the controller Such published notices of suspension or revocation, as the case may be, in all such repositories. So, this is all relating to the very question, that is, give a critical assessment on the regulation of certifying authorities, and the very apt answer that we found relating to appointment and function of controller as under section 17 and 18, and as relating to very application for a digital signature certificate. We discussed the provisions of section 22, and regarding issue of such license we discussed the provisions of section 21, and renewal of that digital signature certificates falls under the provisions of section 23, and regarding the very grant and rejection of such license, the provision of section 24 of the IT Act of 2000 provides the very grounds. Also section 25 and section 25, 26 provides regarding very suspension or revocation of license, and the concerned grounds and procedures of suspension or revocation of license, and notice to be issued concerning such suspension or revocation of license issued by the certifying authorities by the controller. So now we would like to discuss the next important question, that is question number 4, which relates to enumerate the provisions relating to establishment, composition and function of the cyber appellate tribunal. So regarding the very establishment of the cyber appellate tribunal, we found section 48 of the IT Act, which provides that the central government shall by notification establish one or more appellate tribunals to be known as cyber regulations appellate tribunal, and as such regarding composition of cyber appellate tribunal, section 49 provides the tribunal shall consist of one person only, known as the presiding officer, and be appointed by notification by the central government. And for the qualification regarding appointment as presiding officer of the tribunal, section 50 of the IT Act provides that a person shall not be qualified for appointment as presiding officer unless he is or has been or is qualified to be a judge of a high court, or has been a member of the Indian legal service and is holding or has held a post in grade 1 of that service for at least 3 years. And as such regarding the very term of office, section 51 of IT Act 2000 provides that the presiding officer shall hold office for a term of 5 years from the date on which he enters upon his office or until he attains the age of 65 years, whichever is earlier. And now we would like to discuss regarding the very resignation and removal as provided under section 54 of the IT Act. The presiding officer may, by notice in writing, address to the central government, resign his office. The central government may, by order, remove the presiding officer on the ground of proved misbehavior or incapacity. And now we would like to discuss the provisions laid down under section 55 of the IT Act regarding orders constituting appellate tribunal to be final and not to invalidate its proceedings. So, no order of the central government appointing any person as the presiding officer shall be called in question. Further, no act or proceeding before the tribunal shall be called in question on the ground merely of any defect in the constitution of the tribunal. And now we would like to discuss the provisions relating to appeal to cyber regulation appellate tribunal as provided under section 57 of the IT Act. So, any person aggrieved by an order made by controller or an adjudicating officer may prefer an appeal to the tribunal. However, no such appeal shall lie from an order made by an adjudicating officer with the consent of the parties. Every appeal shall be filed within a period of 45 days from the date on which a copy of the order made by the controller of the adjudicating officer is received by the person aggrieved. On receipt of an appeal, the tribunal may, after giving the parties an opportunity of being heard, pass such orders thereon as it thinks fit, confirming, modifying, or setting aside the order appealed against. And now we would like to discuss the very procedure and powers of the tribunal as provided under section 58. The tribunal shall not be bound by the procedure led by the Code of Civil Procedure. Instead, it shall be guided by the principles of natural justice and subject to the other provisions of this act and any of its rules. Also, the tribunal shall have powers to regulate its own procedure, including the place at which it shall have its sittings. Further, the tribunal shall have the same powers as are vested in a civil court under the Code of Civil Procedure while trying a suit in respect of the following matters, namely, summoning and enforcing attendance of any person and examining him on oath, or requiring the discovery and production of documents or other electronic records, or receiving evidence on affidavits, or issuing commissions for the examination of witnesses or documents, or reviewing its decisions, or dismissing an application for default, or deciding it ex parte, or any other matter which may be prescribed. And now we would like to discuss, besides the bar and civil code jurisdiction, now we would like to discuss the very bar that is provided under the Act under Section 61 that no court shall have jurisdiction to entertain any such suit or proceeding in respect of any matter which an adjudicating officer or the tribunal is empowered to determine. Further, no injunction shall be granted by any court or other authority in respect of any action taken or to be taken in pursuance of any power conferred by or under this Act, Information Technology Act 2000. And now we would like to discuss the right to legal representation as provided under section 59 of the IT Act. The appellant may either appear in person or authorize one or more legal practitioners or any of its officers to present his or its case before the tribunal. And now would like to the very limitation as provided regarding an appeal under Section 60 of the IT Act of 2000. The provisions of the Limitation Act 1963 shall for as may be applied to an appeal made to the tribunal. And finally, would like to discuss the provisions relating to appeal to High Court as provided under Section 62 of the IT Act 2000. So, any person aggrieved by any decision or order of the tribunal may file an appeal to the High Court within 60 days from the date of communication of the decision or order to him on any question of fact or law arising out of such order. So, the very answer that we have discussed relating to question number 4, that enumerate the provisions relating to establishment, composition, and functions of the Cyber Appellate Tribunal as we found under the Information Technology Act of 2000, the Section 48 and Section 49 deal with establishment and composition of Cyber Appellate Tribunal, and Section 50 and 51 laid down the qualifications and terms of office of those presiding officers of Cyber Appellate Tribunal, and Section 54 provides regarding resignation and removal of such presiding officers of Cyber Appellate Tribunal, and Section 55 provides that no proceedings of the Cyber Appellate Tribunal could be invalidated, and Section 57 provides regarding appeal to Cyber Appellate Tribunal the very procedure and powers to be followed by the Cyber Appellate Tribunal is provided under Section 58 of the IT Act, and Section 61 impose bar on the civil court jurisdiction regarding application of civil court jurisdiction to the Cyber Appellate Tribunal, and Section 59 of the Act deals with the right to legal representatives for regarding appeal before Cyber Appellate Tribunal, and Section 60 deals with the limitation as provided under the Limitation Act 1963 regarding any appeal made to the Cyber Appellate Tribunal, and finally Section 62 of the IT Act provides appeal to High Court of any of the order or decision of the Cyber Appellate Tribunal against such order or decree or decision of the Cyber Appellate Tribunal could be appealed before the High Court as per the provisions of Section 62 of the Information Technology Act of 2000.